Welcome back to the Global Council powered by WONE. I am Subarna, and today we are asking a question every business leader should think about. Why do you need legal assistance before the problem occurs and not after? Joining me is Andrzej Zacharzewski, founding partner at Zacharzewski and Partners in Poland, an internationally recognized expert in banking, finance, and arbitration, and a valued partner at WONE Global. Andrew, thanking you for being here with us today. Before we dive in, why don't you give us a quick introduction about yourself, your practice, and what drives your work?
Thank you very much for the invitation. I'm happy to be able to work with such wonderful people who made up WONE Global. I came from a country that began building a market economy in the early 90s, and this period coincided with the beginning of my legal career. I can say that as a lawyer, I grew up alongside the economy, observing successive changes, the emergence of the new problems, and how they were solved. So I'm an attorney, arbitrator. My law firm provides legal services for international transactions, from goods to capital flows and intellectual property. I'm an arbitrator at the Court of Arbitration at the Polish Bank Association, where I deal with the disputes concerning financial instruments. I'm also chairman of the Council of the Court of Arbitration at the Krakow Chamber of Commerce, where we deal with common disputes between entrepreneurs. And I can see how much the economy is globalizing, even in these times when the old order is crumbling before our eyes. It is no longer possible for lawyers to operate solely on the local basis, and this makes the opportunity to participate in WONE Global, a platform that connects professionals in the divided world, all more valuable. And of course, I invite everyone to Poland. It's a very good place to live and invest, and I will be happy to assist you.
That was great. Thank you. Now, you advise clients across borders. So, what kinds of risks typically blindside international companies, like especially in contracts, finance, or compliance, when they wait too long to involve legal counsel?
People often believe that legal services should only be used when a problem arises. A lawyer is therefore treated as a kind of cure for an illness. However, to avoid illness, you need to eat properly, take care of your fitness, and lead a healthy lifestyle. The same applies to the legal services. Prevention is always better than a cure. That is why clients who are aware of this use our risk management services. This is much cheaper than minimizing losses caused by lack of adequate preparation. For example, recently, one of our clients called with the following problem. He had several promising business meetings with the potential buyer of his products. It was foodstuff with a determined shelf life. The buyer expressed interest in purchasing a significant quantity of the product under its brand. Everything was agreed upon verbally. The client manufactured, packed, labeled the goods, but the buyer is delaying the delivery due to the unforeseen difficulties. So, since the parties did not prepare a contract or outline a framework for cooperation, we have limited room for the maneuver. We cannot sell it to another buyer since it is already branded. And simultaneously, the time of the shelf life of the product is running out. But there was undoubtedly a contract concluded, orally, but both parties expressed its will. The problem is that we lack details, agreed upon procedures and evidences. Meanwhile, all you had to do was ask a lawyer before starting production. Usually a simple order and its confirmation before rather than after manufacturing begins is sufficient. This is a simple example of the simple mistake which could be very costly. Engaging legal services before a problem escalates is far more strategic and cost-effective approach than seeking help in the midst of the crisis. Why? Let's look at the cost savings. Proactive legal advice can prevent costly disputes, litigation, and regulatory fines. Addressing issues early often involves simpler, less time-consuming, and therefore less expensive interventions. Look at the risk management. A lawyer can help identify potential legal pitfalls and implement measures to mitigate them. This foresight is crucial for safeguarding your assets, reputation, and future operation. It is about building a strong legal foundation rather than trying to patch up a crumbling structure. Also, when the crisis hits, a lawyer's hands are often tied. Our ability to negotiate a favorable settlement, explore alternative dispute resolution, or even prevent legal action altogether is significantly diminished. In a crisis, we are often reacting to events. We are not shaping them, and available legal remedies may be limited and less advantageous. That's what I think about it.
All right. Like these aren't just like issues, and I feel you very well told in very brief like how and why there is need of risk assessment, like before and not after. Like that was very clear. Thank you. Now, you have written extensively on letters of credit, bank guarantees, and arbitration. Could you share how regulations and dispute resolution mechanisms play into risk management? For example, when should people like think about arbitration clauses or financial safeguards?
Well, I think that one of the most critical risks international companies face when delaying legal counsel is non-performance or delayed or defective performance in contracts. This can stem from a failure to understand and comply with the unique business structure, tax laws, and industry-specific regulations of the foreign countries. One must consider numerous factors, including custom issues, sanctions lists, determining the ultimate beneficial owner, counteracting money laundering. Additionally, we must consider data protection, environmental protection, waste management regulations, food quality regulations, and thousands of similar issues. For instance, let's try to imagine that the company is trying to enter into a simple distribution agreement, but without adequately strategizing for legal risks. Such oversights can lead to costly fines because non-compliance with the local laws can result in insubstantial financial penalties. Contractual breaches, this includes violations of payment terms, misrepresentation, or arbitrary fraud, all of which can derail business operations and damage the reputation, which is very important. The reputation sometimes is the key. Also, it may result in the inability to enforce entire agreement without proper legal grounding. Companies may find their contracts unforeseeable in foreign jurisdictions. Imagine you are a construction company entering a construction contract overseas without complex knowledge of the local constraints. This happens, for example, to Chinese road construction companies that participate in tenders for the constructions of motorways in the European Union, in Poland as well, without paying attention to the provisions of the tender specifications and hoping that in the event that the price changes or in case of some delays, it will be possible to renegotiate contract or implement some changes to its terms. But usually a bank guarantee is required as a security for the performance of such contract, and tenders are announced by the state authorities, which are very reluctant to change the original terms and conditions but also very willing to take advantage of the guarantees. The bank doesn't care. If there is a demand for the payment, it is formally correct and the guarantee amount should be paid. But as a side effect, the investment will no longer be carried out and this company is fired out from the market just because they didn't pay enough attention to the local constraints, circumstances, culture, and regulatory environment.
Wow, there are so many factors that like come into account when you are looking at drafting, like the local factors you just mentioned and the cultural. So, good drafting and foresight in contracts are as much about protecting relationships as they are about winning the disputes later. So, you've sat on both sides as a mediator and as a counsel. What are some lessons from disputes you've seen that could have been avoided with earlier legal involvement?
Um, I think that it should be I would recommend to start from the very beginning because already at the stage of establishing contact with the potential contractor, we can use, for example, an AI agent to check the financial liquidity, assets, payment backlogs, owner structures, and finally make a recommendation to start cooperation. If there are no red flags, it is also worth considering methods of securing the performance of the contract. For example, this could be export insurance offered, for example, by institutions like Sinosure in China or the European equivalents. Also, bank guarantee is expensive, but for example, letter of credit, also not so cheap, is more accessible and recommended, especially when economic cooperations is just beginning. As for arbitration, I will always encourage it for many, many reasons. First of all, many arbitration courts offer the possibility of conducting cases online without the need of costly and time consuming travel. It is invaluable advantage. Also, the advantage of the arbitration is that the adjudicating panel can be composed of practitioners from a given industry who know the specific of the market. What's more, the development of technology has made it much easier to use arbitration without traveling far. For example, last year in the Court of Arbitration at the Chamber of Commerce in Krakow, we developed new regulations for this court, which provide for online proceedings and submissions of documents in digital form. We eliminated the circulations of paper documents, and this way, without leaving Singapore or India or Australia, you can participate in the hearing on the other side of the globe. And we are not the only ones. We are not the extraordinary court in this matter. Similar solutions are being implemented all over the world. So, arbitration is no longer a mahogany table in Geneva affair. It is, let's say, Zoom calls, clouds uploads, and people in sweatpants resolving billion-dollar disputes. Arbitration is not reserved exclusively for large companies and significant disputes. In addition to considerable renowned arbitration courts like, for example, CETAC or Arbitration Institute in Stockholm, Vienna International Arbitral Center, there are dozens of small but well-prepared arbitration courts in the world with the appropriate intellectual and organizational background to resolve international commercial disputes between large, medium, and small companies.
Like it was also very insightful how you just told us how you made arbitration like completely paperless, like the integration of AI that you have been doing also in your practice. Right. Most disputes don't start in the courtroom, but they start in the contract. So, looking forward in today's fast moving world of cross border investment and digital business, what is your one piece of advice to business leaders about building risk management into their strategy from day one?
It's a difficult questions because everyone may give different answers. So, from my point of view, it's just my opinion. Many problems stem from carelessness. There is a such thing like unconscious incompetence. Someone wants to do business but doesn't know what he doesn't know. So they do not seek the legal advice and they are hoping that somehow it will work out. And when the transaction falls through, it is often too late. And all we can do is to try to limit the losses. So it is important to formulate expectations precisely and assess the information received soberly. I believe there is no problem that cannot be solved, but many could be avoided if we did not take our own expectations as facts. This error of perspective, this is called cognitive distortion angle, sometimes means that although both parties use the same language, they attach different meanings to the concepts. For example, I give you an example. The phrase, it would be difficult, can mean both. No, definitely, forget about it. Or it may mean we have to include it in the price, but it is feasible. And this is important to be sure that both parties understand the same by this expression. Also, another problem is underestimating the formal aspects of arbitration proceedings. If it comes to arbitration, of course, because it is said that arbitration proceedings are less formal than court proceedings. This is only partly true. As an arbitrator, I have seen many cases that were lost because parties conducted them sloppily. Arbitrators are supposed to be impartial, so we cannot suggest what evidence to submit or in what form and when. We must ensure that the proceeding will be running smoothly. So we have to respond, for example, to any cases of so-called unsolicited filings or not providing the procedure. So you can be very careful even if you arbitrate. And of course, there is a lot of other details, and I'm pretty sure that everyone has got its own experiences in this matter.
All right. So your perspective for me personally felt very insightful in terms of how arbitration has is commonly seen and as being an arbitrator what you feel is the actual scenario in that. So that was like that part was really insightful. So the takeaway is like clear. Legal foresight is a competitive advantage. Mr. Andrew, thank you for bringing such practical clarity to this conversation. It's been sharp, insightful, and full of lessons for anyone working across borders. We're proud to have you as a One Global partner, and this is the Global Council powered by One. Until next time, stay sharp, stay global.
Thank you very much.